Hello everyone. I have prepared this dictation of 500 words at the speed of 90 words per minute. If you guys practice this thoroughly and sincerely, then the required speed of 80 words per minute for Rajasthan District Code exam will definitely seem very easy to write. Practice this passage multiple times to gain perfection. All the best.
Since we are inclined to dispose of this appeal on one short ground, we consider it unnecessary to give details of the facts leading to filing of the writ petition and the order passed by the learned single judge full stop. Quintessential facts are that upon institution of a criminal case, the appellant was placed under suspension full stop. Institution of criminal proceedings eventually culminated in conviction full stop. This led to termination of services full stop. The appellant filed criminal appeal in which she was successful and the conviction was set aside and she was acquitted full stop. This gave rise to necessity to reinstate the appellant in service as the only basis for termination was a criminal case and not a departmental inquiry. Full stop stanza. Though the appellant was reinstated while giving treatment to the period of suspension, it was held that for the period from 2012-2002 till 9/5/2007, that is, the period during which appellant remained out of employment on account of termination as a result of conviction, the appellant would not be entitled to any wages full stop. At this juncture, the appellant filed writ petition challenging that part of the order dated 22/5/2008 full stop. Before the learned single judge, the appellant, amongst various grounds, also challenged the decision on the ground of impropriety in decision-making process, that the order was passed without affording any opportunity of hearing full stop. Learned single judge, however, was of the view that in the present case, as it was not a case of honorable acquittal, the appellant was not entitled to any relief full stop. The disciplinary proceedings against the respondents in both the cases have not culminated in a situation where it could be said that they have been completely exonerated full stop. This would take their case outside the four walls of Rule 54 of the rules full stop stanza. Their suspension may not fall in the category of unjustified suspension full stop. This inevitably and necessarily would bring their cases within the scope of Rule 54 full stop. This would necessarily mean that the exact amount of pay and allowances to be paid is to be less than the full pay and allowances full stop. However, this exercise can be done only after notice to the employee full stop. Admittedly, there is a failure by the appellants in this regard full stop, but at the same time to remit it back for this purpose in our view would be inequitable full stop. Hence, we would rather adopt the middle path by directing that in the facts and circumstances of the case, the respondents be paid pay and allowances fixed at 50% of the pay and allowances which they would have drawn for the period of their absence full stop. Accordingly, The appeals are partly allowed full stop. We direct that the respondents in both the cases will be paid the pay and allowances at 50% of the amount which they would be entitled for the period in question full stop. As to what treatment is required to be given during the period of suspension would lie within the discretion of the authority full stop. Therefore, it cannot be said that there is any straitjacket formula based on rule and facts full stop.